Hi, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about litigation loans. Cases that should have gone to the Supreme Court of Canada, but didn't. Kimberly Isbister was injured in a motor vehicle accident, and like many people who are injured in motor vehicle accidents or other unfortunate circumstances, she didn't have the money right away to finance the complex and lengthy litigation that she was going to go through as a result of her accident. And there are companies that deal with this. There are companies that provide loans at very high interest rates to finance litigation and to allow individuals to pay for the disbursements necessary to bring their cases to court. Ms. Isbister claimed recovery of the interest on the litigation loan that she took out, seeking to have that money paid back to her as part of her settlement because it was a cost incurred as a result of her injury. The BC Supreme Court denied giving her the interest payments back. The Court of Appeal agreed, and she sought leave to the Supreme Court of Canada, which was denied. This case presents a very interesting issue because it deals with people who are not financially capable of accessing court resources and deals with circumstances where those individuals have to reach out to third parties, often at alarming interest rates, in order to fund litigation to pay for out-of-pocket expenses and future income loss that they're going to experience as a result of their injuries. It seems to make sense that those people should get that loan back, the interest on those loans back, and be put in a whole position rather than only in a partly whole position. After all, making people whole is the purpose of civil damages recovery. And so Ms. Isbister's case was a good opportunity for the Supreme Court of Canada to clarify how people get their money back in circumstances of litigation loans and in circumstances where they don't have the financial resources to take their case to court without seeking out these loans. The Supreme Court of Canada essentially did a significant disservice to people who are of limited financial means and who need the courts to assist them as a result of their injuries. Not everybody can afford to pay hundreds of thousands of dollars in advance of a settlement after being injured and off work. And the Supreme Court of Canada failed to recognize that and let people in Ms. Isbister's position down. I hope that next time the Supreme Court of Canada creates a good mechanism whereby people can recover these costs and that litigation can be fairly advanced and not only a privilege afforded the rich. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to this episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, share with your friends, and tune in next week for another video.